Thank you, Derek. Welcome everybody to our third event, as Derek said, on this conversatory on racism. I'm very happy that you're all participating. Also, all of you who have joined the discussion sessions, a lot of things came up, and I would like to continue this conversation. Today we have a great speaker. This Professor Franita Tolson. She's the Vice Dean for Faculty and Academic Affairs and law professor at University of Southern California Gould School of Law. Her scholarship and teaching focuses on areas of election law, constitutional law, legal history, discrimination. She testified to Congress and has many articles, clerked. I mean, you've read her bio, and she has a book forthcoming, Rethinking the Constitutional Structure of Political Rights, the Evolution of Federal Voting Rights Informant from the Founding to the Dawn of the Progressive Era. Oof, did I get that correctly? So it's coming up next year by Cambridge University Press. Thank you so much, Franita, for joining us today.
Thank you for having me. Very excited to be here to have this conversation.
So let's jump right to it. This is about voting rights and political rights. There's no other litmus test, we could say, to see who is or is not part of the political community, who is by law and by facts a full member of the political community. And we know that the exercise of political rights in this country is very uneven and complex, to say the least.
Yes.
So to lay the groundwork, I would love you to tell us all and instruct us on this gnarly web of pieces of legislation that relate to voting rights, to the exercise of political rights. What are the different constitutional pieces of legislation involved in voting?
So wonderful question. And I really like how you framed it in terms of political community, because each state really is its own political community. So voter qualifications, i.e. the question of who can vote, is determined mostly by state law. So in every state, you have to be a citizen. You have to be at least 18. But other requirements tend to vary. So, and most states have some restriction on the ability of individuals with felony convictions to vote. Almost all states have some sort of residency requirement to vote. So there's different variations in restrictions, and it is mostly dictated by the states. But the federal Constitution does speak to certain limits on the ability of states to disenfranchise people. So, for example, the 15th Amendment prohibits states from discriminating in voting on the basis of race, right? So that was passed in response to the Civil War during Reconstruction to address African-American disenfranchisement. The 14th Amendment is also a restriction on the ability of states to discriminate in voting. So in the 1960s, the Supreme Court found that there was a fundamental right to vote in the 14th Amendment, even though the text itself, so the constitutional text does not explicitly mention voting, the court read it in there, right, in order to provide more protection to the right to vote. There's also federal legislation that protects voting. So most famously is the Voting Rights Act of 1965, which the most successful provision of the act is Section 4B and 5, which required states that had really terrible records of discriminating on the basis of race in voting to pre-clear any changes to their voting laws with the federal government before those changes could go into effect. So basically they had to ask permission to change their voting laws because they were so bad on racial issues in voting. However, in 2013, the Supreme Court struck down that portion of the Voting Rights Act. There are still pieces of the Voting Rights Act that remains. So there's still a provision where states can be sued for discriminating on the basis of race in voting under federal law. But the preclearance provision, which was by far the most successful provision of the Voting Rights Act, is no longer valid.
So this is great. Before jumping into Shelby County, that is the strike down to 2013 that you're
Mhm.
mentioning, can you tell us about the electoral clause?
So the elections clause is,
Election clause, sorry.
no, it's okay. So the elections clause is Article 1, Section 4 of the Constitution, and it directs states to set the times, places, and manner of federal elections. So when you vote for your congressman, you are voting from a district, and pursuant to the elections clause, the states are drawing those districts. The important part about the clause, though, is the fact that Congress retains the ability to make or alter state regulations. So technically, Congress could come in and displace state law with respect to the time, places, and manner of federal elections. So it's a really broad source of authority for Congress. They don't use it that often, though. There are a couple major pieces of federal legislation that was enacted pursuant to the Elections Clause. So most people are probably familiar with the National Voter Registration Act, because when you go to renew your license, you can register to vote. So that's the National Voter Registration Act. Less familiar is the Help America Vote Act, which is basically a piece of legislation that provided funding to the states to improve their election administration.
Mm-hmm. This is vast, and you set up something that begs the question: what's a relationship between the states and the federal level? And I know that this goes to the core of your work and your
Mhm.
argument forthcoming in your book, and also in a article published last year. So
Mhm.
if you can tell us a bit about this complex relationship between Congress and state vis-a-vis
Mhm.
voting rights, and also what are the instruments that the states basically are using to curtail voting rights, because they are complex, subtle,
Mhm.
sometimes immoral and blunt, and I'm disclosing too much, but that's how I see them. So
Yes. So the relationships between the relationship between the states and the federal government has been fraught, to say the least. So I think that if anyone has seen the movie War of the Roses, that married couple is the federal government and the states. That's the relationship. They are like a couple on the verge of divorce. Um,
interesting point.
so so over the last 150 years, you really have a situation in which states have been aggressive in trying to limit the scope of their political communities, right? Trying to limit the number of people who can vote, and even more pointedly, the type of people who can vote. So it's not just African Americans; it's also Latinos, Asian Americans, immigrants. Uh, States used to discriminate on the basis of religion with voting, on the basis of disability. So states have a history of discriminating across a broad range of categories. And so federal law has really been important for pushing back against some of that. The problem, though, is that the US Constitution gives states broad authority to set voter qualifications. And for a long time, our, I guess, traditional view of voting was about proving that you were sufficiently independent. So how does one do that? Right? You do that by proving that you are wealthy enough, that you will vote, and it's you voting, and you're not voting under the influence of anyone else. So poll taxes, for example, were really, really common, where you had to pay a tax in order to vote, because it was a way of showing that you had sufficient independence in casting a ballot, that you weren't under the influence. Whereas the concern was that, if you let people who are poor vote, or people who are minorities and considered racially inferior, if you allow them to vote, then they won't be sufficiently independent. So federal law was really important for pushing back against a lot of that. This is why the Voting Rights Act was really, really important. But there were other constitutional amendments during the 1960s that also broadened access to the ballot. So, for example, there's a constitutional amendment, the 24th Amendment, that prohibits poll taxes. The 26th Amendment gave DC residents the right to vote. The 28th Amendment, I think I mixed them up. 26th Amendment is giving the vote to people 18 and older. So there were basically three constitutional amendments, and the Voting Rights Act, and judicial case law, all of which had the effect of limiting the state's ability to disenfranchise people across a range of categories. And so post 1960, what you saw was a huge increase in the electorate. right? Turnout was up among groups that had been historically disenfranchised. This is why the Supreme Court's decision in 2013 was so, I don't want to say shocking, because shocking suggests that it came out of nowhere.
Mhm.
In fact, there were a series of cases in the early 2000s that suggested that the court was headed in that direction, right? The court had started to be more suspicious about uh, the Voting Rights Act and the fact that it intruded on state sovereignty because it forced states to ask permission, right? So if the Constitution says to the states, hey, states, you have the power to set voter qualifications, and then the federal government is saying, but you need to ask us first, that seems contrary to what the constitutional text structures, according to the court, right? Because the states themselves are sovereign entities, right? So if they are truly sovereign, they should not have to ask permission from the federal government to do what the Constitution has allowed it to do. The problem is that the states have abused this authority, right? And to some extent, the Shelby County decision is not responsive to the fact that states had continued to abuse their authority. And what we've seen post 2013 is that they are still abusing their authority, right? And so the invalidation of the pre-clearance provisions of the Voting Rights Act really did open the door for a lot of voter suppression and voting abuses. So to give you just a few examples, in states that were formerly covered by Section 5 of the Voting Rights Act, so these are the states that had to ask permission, they closed 20% more polling places on average than states that were not covered by the Voting Rights Act.
May I interrupt you to
Sure.
rewind a little bit? Because we'll move to, I mean, the tension between, state sovereignty and federal sovereignty, because that's at the core of any federalism, right? So it
Yes.
depends on whether morality prevails or abuse, as you put it. But let's leave that a little bit. I want to rewind a little bit, if you can spell out what happened, what's Article 5, what's Section 5, what's the formula, what the formulas are in 4B, why the Supreme Court found them unconstitutional going back, and if you can address why Congress didn't change the formulas in 2006 when it renewed the Voting Rights Act, so that people have like the whole map of what happened.
Okay, sure. In Shelby County versus Holder, the Supreme Court invalidated the coverage formula of Section 4B because they found that the formula had not been updated in 40 years, and it was based on practices that were no longer in existence. So, for example, coverage was determined by states that use literacy tests and poll taxes and so on, and that determined whether or not they had to pre-clear any changes to their laws with the federal government. Because those things are no longer in effect, right? Poll tax is unconstitutional, literacy tests are banned by federal law. Because that was the basis for the formula, the court found that Congress needed to update it. And the updating became especially important given that discrimination in voting is down, right? So the prevalence of intentional racial discrimination. So racial discrimination in which you have state actors who are deliberately disenfranchising people and being intentional about disenfranchising people on the basis of race, as opposed to just adopting rules and regulations that have a discriminatory impact, right? That doesn't mean it was necessarily passed with the intent of discriminating on the basis of race. The court found that Congress needed to build a record of intentional discrimination, right? It's not enough for something to just have a discriminatory effect. That record was missing, according to the court. And also the formula was outdated. So the court struck it down because without those things, the intrusion on state sovereignty in the court's view was not justified, right? We have to return back to the original baseline in which the states exercise control over elections and voter qualifications unless Congress can justify its intervention. And the court found that Congress had not reached that threshold of showing that the pre-clearance provisions remained necessary.
So that's an excellent, I mean, that's, anyways, that's the argument of the court. I mean, I'm missing the words because it's so appalling. But I mean, there's here like both like a legal and a political question that I would like to ask. I mean, the extension of section on the Voting Rights Act happened in 2006, right, by
Yes.
Congress. And it's my understanding, and of course, I'm not an expert in the field, that it was bipartisan and with a wide majority, and it was extended
Yes.
for 25 years.
Right.
So my first question is, what happened since then, in that term? And the second is like, how come they didn't update the formula? They didn't think that there would be a backlash? Like, what happened?
Well, there's always a backlash. Every time Section 5 is reauthorized, there's litigation over its constitutionality. It was prior to 2006, it was last reauthorized in 1982 for 25 years. And prior to that, it was reauthorized in 1970. So each time you had litigation that followed challenging the constitutionality of Section 5. So I don't think Congress would, I think they expected it, but the reason it was bipartisan was because they didn't update the formula, right? I think that because keep in mind, there were election law experts that testified before Congress and pointed out that the formula needed to be updated. So it wasn't like this was a secret. But I do think that in terms of forming a coalition around a reauthorized Voting Rights Act, changing the formula would have fractured the coalition. Because a lot of people in Congress voted yes without really believing that Section 5 continued to be necessary. It really was, and for some of them, par for the course to vote for it. And so imagine the conversation around a new formula, which might potentially subject new states to preclearance. I do think that would have been more politically contentious. And so another thing that sort of bolsters my belief that a new formula would have had more difficulty passing is if you look at the legislation that has come out of the House, to reauthorize the Voting Rights Act, it's not bipartisan, right? So there's no longer a bipartisan coalition that supports the Voting Rights Act. So one might say that, maybe that is a function of our politics now, right? Things are really, really polarized. Maybe it would have been easier in 2006, possibly. But one thing I can say for certain is that it certainly wouldn't have been as overwhelming as it was had they changed the formula, and it would have been more difficult to pass.
Definitely, because de facto what's going on is that what this happened is that by invalidating, let's say by declaring the formula unconstitutional, they're basically disabling Section 5 altogether until there is a new formula.
So there's a pre-clearance regime with no states that are covered because we don't have a new formula.
Exactly. So what are the guarantees right now that we have against discrimination, being that the case?
So I'll answer that, but I also want to fold in a question that we have in the chat about what's needed to correct the court's decision. So Congress can pass a new coverage formula. And so the question, I think, after Shelby County is what record is sufficient to justify a new formula. And so I think the formulas that are currently being discussed, including the one that has gotten the most support in Congress, they're trying to make it so that when we talk about coverage, it's rolling. So states have to, in order to be covered and have the pre-clearance regime apply to you, you have to commit current violations. So it's not based on, practices that are 40 years old. Instead, what it does is it focuses on people who have committed recent voting rights violations, and then the state can be subject to pre-clearance. It's also based on something called known practices. So there are certain practices that have historically been tied to voting discrimination, such as closing polling places, annexations, things like that. So known practices could also, when states engage in those, they could also lead to coverage under the pre-clearance regime, or that practice would be subject to pre-clearance. So they're trying to get away from the Shelby County decision and the concern about singling out the South. That was an important part of the decision that we didn't really talk about, because the court seemed to be motivated by this idea that the reason that we are concerned, we the court, about the outdated nature of the coverage formula is because it's singling out a jurisdiction, i.e. the South, when there are violators in the North, right? So that's a problem of tailoring, right? If Congress has to justify exercises of its authority, and the traditional baseline is that the states have control over this area, then it's really important for federal legislation to be tailored to the problem that it is trying to address. If you're singling out Southern violators and not Northern violators, then it's not sufficiently tailored, right? So by tying the new formulas, by tying it to current violations, by looking at known practices that have usually resulted in people being disenfranchised or their vote being diluted, that is a way of targeting states regardless of where they're located.
So that's a great point, because then you have Florida, right? And Florida was not covered under the formula, was it?
It was.
And then you have Wisconsin, and then you have Rucho versus Common Cause about gerrymandering. That seems not to be like a known practice for unreasonable results. So besides my frustration that I'm going to set aside, I mean, there seem to be in the understanding of who's part of the political community and who's not part of the political community, like two different sets of levels. On the one hand, you have the kind of the legal and the practical, the jure and de facto, right? Like who is legally entitled to vote and who is actually allowed or facilitated to vote. You know, that's like one set of level. And the other level that is at the core of this conversatory of racism and reckoning with, you know, the history of this country is that basically there are two understandings of who is a full member of the political community. And they align along kind of Republicans and Democrats more or less, and along, you know, federal, but not the Supreme Court, and the states, which is like an ethno kind of racial understanding. Only the whites, but it depends on how you define the whites, are part of the political community, or it's actually a civic community that is constituted by everyone by, you know, the right of birth or naturalization in this country, right? How does that kind of get solved? Well, get solved is like a huge question, right? But gets addressed, you know, at different level of politics to just channel it towards like a civic understanding.
That's like a what is the meaning of life question, right? So I think that I think it's hard. So if the way I like to think about it in my head is that we really have overlapping political communities, right? So there's a political community of we the people. So we the people is not necessarily the community of we the voters, which is a community that I think about as separate and distinct from we the people. If you think of we the people as being its own community, then technically we are all part of a political community, even if we're not exercising the political power of the community, which is exercised by we the people. And so I do think that there's a tension, though, because a lot of times there are people who belong to the political community of we the people, but are entitled to belong to the political community of we the voters. And I think our historical tendency has been to try to keep the community of we the voters smaller than it otherwise should be. And these political communities are very important because historically, if you look at the community of we the people, African Americans weren't even a part of that community. That's the Dred Scott decision, right? And so while we've been able to more fairly incorporate African Americans into the community of we the people, we're still having arguments, and we'll continue to have arguments about the contours of we the voters, even knowing that there are people in we the people who deserve to be in we the voters. But as long as we have these parallel communities, and in some ways it's inevitable because of the way our political system is set up, right? We have 51 different political systems, 50 states, Washington, D.C., and then there's the federal system, right? As long as we have that, it'll always be a competition between these communities.
Right. Yes. You are living. I mean, I'm Argentine, so we usually use soccer metaphors. So you left the ball bouncing for me to ask you, this question, which is, I mean, we may be jumping ahead, but what do you think about mandatory voting? Because the mandatory voting, which Argentina has, but not only, there are 32 countries that have mandatory voting. Most of them, interestingly enough, are in Latin America, like 12 of them are in Latin America. But the mandatory voting would solve all of these issues. Now, that's a huge problem because I mean, I really love like this tension that you said between we the people and we the voters. There's also a tension in political rights. I mean, we usually refer to them as political rights, but we can understand voting as a duty.
Yeah.
Vis-a-vis the political community as opposed to a right? We pay taxes, right? That's a duty. We need to vote. We need to be responsible for who we choose, right? So that can be seen as a duty, and that's at the basis of mandatory voting. So what's your kind of personal opinion about mandatory voting and your opinion about the likelihood in this country, which is close to zero, but
yeah. Still worth the conversation, right? Georgia had mandatory compulsory voting at the founding, right? So it's not as if it is something that's completely unknown here. But I do think culturally it's different because we talk about voting rights, but we tend to talk about voting in terms of it being a privilege, right? And this is the only way to justify some of the restrictions we have on voting. If the state pretty much does not have very many obligations to make it easier for you to vote, right? They have to provide polling places. They have to provide ballots. But if you don't have a car, sorry, right? If you don't have the underlying documents to get your ID and you don't have the money to pay for those documents, sorry, right? But a lot of that is tied to the conception of voting as a privilege, regardless of how much rights language we use. So the interesting thing about having a regime of compulsory voting here really ties to the First Amendment. In the 1960s, the Supreme Court rejected the idea of voting as a First Amendment right? The idea that it's a form of political speech, casting a ballot. If there was ever a proposal for compulsory voting here, I think that the court would reject that, and all of a sudden this will be about unconstitutional compelled political speech, right? And so I just think that the court's current jurisprudence on the First Amendment will make it virtually impossible to have any regime of compulsory voting here. Unless you have an amendment to the U.S. Constitution.
Really, because it should be taken as precedent, and with a different configuration of the Supreme Court, it couldn't be interpreted otherwise?
It could, and possibly, yeah.
Yeah,
but keep in mind, this is precedents going back, 5 decades. Not that has stopped the current court from overturning precedents that are older, but just in the sense that I think that particular precedent, so the case was Harper, decided in 1966, instead of thinking about the right to vote as a First Amendment matter, right, a form of political speech, the court opted to think about it in terms of equal protection, so 14th Amendment. And so to the extent that it is about revisiting that precedent, it would also force us to sort of rethink the underlying rationale and conception of voting as a right. And I think that's a little bit more difficult than just overturning a precedent.
Yes, particularly with the particular political configuration now that is stressing the idea of rights and liberty as opposed to, equality.
Right. No, right? Absolutely. Yeah.
So that definitely interfere. So you mentioned also, I mean, you mentioned different bases of discrimination, what are other bases of discrimination that directly or indirectly have an effect on either race or other groups like gender, religion? I mean, wealth tax has been overruled, but you have, in Florida, it's tied to, ex-felons to pay
Mm-hmm.
back the fees. So that is like a hidden wealth tax.
Yes. So Amendment 4, which is the state constitutional amendment that was passed by the voters to re-enfranchise people to give them back their voting rights, people who have certain felony convictions. But then the state legislature passed and the governor signed a law that would require that those individuals to pay all fines and fees prior to being able to
Mhm.
register to vote. And it's really controversial, but I don't think that people realize the extent to which it is like truly disenfranchising, because the state basically makes it difficult to find out how much you owe. Uh, a lot of times the judgments don't even have the amount that people owe on them. And then when people are going to official channels to try to figure out how much they owe, a lot of times that information is not available.
Mhm.
So the Florida, what's going on in Florida reminds me of the poll taxes that were they accumulated indefinitely, and the state never went after you to collect the tax because they had no intention of collecting the tax from people they didn't want to vote. But they made it impossible for you to pay too because it accumulated indefinitely. And so in Florida, you have something very similar to what states used to do with the poll tax, right? And they've now made it a requirement for people to pay their fines and fees, but have made it difficult through sort of a maze of statutes and administrative rules and so on for people to find out how much they owe. But the public has stepped in, though. There is a new website by a Georgetown law professor, a professor by the name of Neil Sukatme, who has put together a website where people with felony convictions can go to try to find how much they owe. So he's trying to help facilitate that process, something that honestly, if the state was serious about the right to vote, they should be providing to, citizens who have felony convictions, but they're not, because the point is to disenfranchise them.
Yes, because there was a judge who said, like, if you can come up in 3 weeks with how much everyone owes,
Yeah.
that would be fine. And that it was like sidestep, like in a
Right.
bypass in some way. That,
Right.
yeah, yeah.
Yeah.
No, this is, and so what's the relationship right now between Congress and lower courts? Because the lower courts seems to be like after curtailing, and limiting, and actually upholding all these decisions, right, that disenfranchise. And the Congress, as you mentioned earlier, has this prerogative, right, this constitutional statute to intervene, to make an alter in some ways.
Yeah, I mean, it's complicated though, because a lot of this is also driven by politics. So the current administration has made a couple hundred, I believe, judicial appointments, which is going to impact the manner in which courts resolve voting rights cases. And so this administration has not been particularly favorable towards voting rights. The Department of Justice has not been as robust in enforcing the remaining provisions of the Voting Rights Act as prior administrations. And so I think at the end of the day, what you'll see is other provisions of the Voting Rights Act coming under fire. So there's one provision in particular I'm thinking about, and it actually ties into one of the questions in the chat about what are the chances that discriminatory impact as a test will be accepted. I think the chances of that are very low. So Section 2 of the Voting Rights Act only requires effect, right? So if a state passes a law that discriminates in voting, but just has a discriminatory effect, it violates Section 2. It does not require plaintiffs to show that the state acted with discriminatory intent. Although discriminatory intent is also a basis for finding a violation of Section 2. It's very possible that the court can invalidate Section 2 because of the focus on effect rather than intent. Because remember our conversation about Shelby County, right? The court is looking for a legislative record that is showing sort of pervasive and overt intentional racial discrimination, right? That is the constitutional standard. Some years ago, Congress used to have more room here, right? They can have a record that has some intentional discrimination, some discriminatory effect. It didn't have to be all discriminatory intent. The court is really pushing back on that now. And so it's entirely possible that Section 2 could be invalidated because it does focus on effect. And there's a disconnect between that and the constitutional standard, which is intent.
Mm-hmm. Yeah, because behind the law, there's always intent, right?
Mhm.
When you just convict a criminal, you have to prove intent. And here is like being very technical, even though the aggregate effect of certain non uh, overtly, but yes, in intention, discriminatory practices, when you cannot prove, a specific intent, but effect, I mean, it's difficult to pin down.
It's difficult to prove intent, right? And it's a certain type of intent, right? So, um, in 1987, there was a Supreme Court case about the death penalty. So, not really voting rights, but the way that the court articulated intent, I think, is important for voting rights
Mm-hmm.
cases. It used to be that you can prove intent by showing overwhelming effect, right? So your point about aggregate effect, you could have so much effect that intent is inescapable, right?
Yeah,
I
yeah.
really think now the court is looking for something akin to, smoking gun statements. We passed this law to, disenfranchise Latinos or African Americans. Now, sometimes that happens. If you live in Texas, for some reason, their legislature cannot stop themselves from articulating their desire to disenfranchise Latinos. It's like they say the quiet part out loud all the time. Uh,
Right.
but but generally speaking, it's kind of hard to find intent outside of those circumstances. There was a Supreme Court case, no, I'm sorry, a Fourth Circuit case out of North Carolina a few years ago where the court was able to sort of infer intent because the effect evidence was just so strong. There was just so many indicators that the North Carolina legislature had targeted African Americans
Mm-hmm.
that the intent finding was inescapable. And so, there are, I mean, cases come up, but they're so rare, and the Supreme Court, I do think they're looking for statements.
Mm-hmm. Yeah, the Supreme Court is taking like a very. So I have a lot of questions, and um, I want to go to the core of your work before jumping on a more general question. So you wrote an article. Well, you wrote many articles, but like this particular, I didn't mean it that way. Um, you wrote an article last year. It was published, the spectrum of constitutional congressional authority over elections,
Mhm,
in which you make a very, very strong argument for Congress kind of ultimate jurisdiction and authority
mhm,
to protect the right to vote, and also not only that, but an aggregate view of congressional
mhm,
attributions, right?
mhm.
That hasn't been looked at by the courts or by anyone. Would you please elaborate on this
Yeah, of
argument
course.
and its implications?
Of course. So one of the things I noticed about the court's approach to deciding if Congress had the authority to pass federal voting rights legislation is that it's very clause bound, right? So they look at individual provisions of the Constitution and they try to determine if that provision gives Congress the authority to do what it's done. The most aggregate the court will get is they'll look at the 14th and 15th Amendments together. But it's not for reasons you think. And that's another reason why I wrote the paper. They look at the 14th and 15th Amendment together, I realized, because racial discrimination in voting will also violate the Equal Protection Clause of the 14th Amendment. It's not because there's an individual right to vote under the 14th Amendment. That's a whole line of cases that the Supreme Court has ignored in thinking about what Congress can do to enforce the 14th Amendment. Because the enforcement provisions of the Reconstruction Amendment, so 13th, 14th, and 15th Amendments, 13th has to do with slavery, 14th equal protection, 15th racial prohibition on racial discrimination in voting. Congress can enforce whatever the Supreme Court says is the scope of violations under those provisions. So if there's a fundamental right to vote under the 14th Amendment, that means that Congress has corresponding authority to try to protect the right to vote from the violations that the court has identified. The same thing with the 15th Amendment, right? If the court has said, well, race discrimination in voting violates the 15th Amendment in these circumstances, Congress can come in and say, okay, this is the remedy that will address the violations that the court has identified. But if the court is solely focused on racial discrimination in voting and just referencing two constitutional provisions that would prevent the same harm, that is an unduly narrow view of congressional power. So what I advocate for in the paper, I say, you know what, let's go even broader than that. It's not just about the 14th and 15th Amendments. it's also about the elections clause, right? So we had a conversation earlier about the elections clause, and the elections clause, which deals with the time, place, and manner of federal elections. Congress can pass regulations that deal with those topics. It's very different from the Reconstruction Amendments, right? So these concerns about state sovereignty and intruding on state sovereignty, these concerns crop up in the context of the 14th and 15th Amendments. It does not really crop up in the context of the Elections Clause
Election clause.
because of how it's structured. So the Elections Clause, it says that states can take the first crack at setting the times, place, and manner of federal elections. Congress has the power to make or alter those regulations. That power is not limited by anything, right? It doesn't, they don't even have to have a reason to step in. Whereas under the 14th and 15th Amendments, the court is looking for a record, right? Like if you are acting pursuant to the 15th Amendment and you claim that there is racial discrimination in voting, you need to show us, right?
Mm-hmm.
That is basically what the court is saying. In the context of the Elections Clause, Congress can say, hey, state, I don't like how you drew your congressional districts. We're going to do it. No reason needed. That is a really broad source of power.
That is certainly a really broad source of power that has been unused. And
Yeah.
actually, what you're arguing is that more cases should be argued on these bases as opposed to the 14th and 15th Amendment, actually,
Yeah.
to get like a more impact. Because if I'm not wrong about this, the 14th Amendment, as you said, it doesn't state the right to vote, and it says, citizens and privileges, but it's not spelled out. So for example, Puerto Rico, they are citizens, but I don't know what's going on because being residents, they can't vote. They can't vote for their own representative. They can't vote for federal elections.
Yeah.
So the status of citizenship in the 14th Amendment does not automatically give you the right to vote, right?
Right. So states still determine the right to vote, but this is why you need all of them together. So what the article argues is that it wouldn't solely be based on just the election clause either. But instead, what I do is I urge the court to look at congressional power in the aggregate, right? Because if you just focused on race discrimination in voting, then of course you'll think that Congress's power is more narrow than it actually is. Because if you focus on all of these things, Congress's power to make or alter the time, place, and manner, Congress's power to regulate race discrimination in voting, Congress's power to also protect the right to vote under the 14th Amendment, all of those things together give Congress broad authority in this area. But because they're looking at it on a clause by clause basis, they're missing that.
Mm-hmm. What would it take politically, to get to that understanding or that look, for Congress to enact, these measures?
A different Supreme Court majority.
We go back to the sources.
So you would have to have a Democratic Senate, a Democratic president, and a couple Democratic justices, because the priorities of the political parties are very different at this point, right? The Republican Party, and this is empirically true, they do better when voter turnout is lower. And so because of that, that affects their view of the scope of the right to vote and whether or not it's a right versus a privilege. In contrast, Democrats tend to do better when voter turnout is up. And so because of that, the party's positions, and this is the part that makes me sad, a lot of this is driven by who controls the processes of government and how well do they do under various models, as opposed to objectively looking at the right to vote as a right that people are entitled to, no matter who's in power. But that's not our system.
Right. Well, but here we go to like a completely different level of conversation, about morality and legitimacy, and how certain part of this country has lost a moral backbone. I would put it in those terms. I'm not, saying that you are putting those terms, but I mean, it's a negative feedback loop, because the less people vote, the less Democrats we're going to have, and the less Democrats are going to be. There are more restricting laws on voting rights would be passed, because the state legislators are in the hands of the Republicans, and they have been working like day and night little by little to
Yes.
enforce these restrictions. So I have a question here that says, can congressional authority be exercised by a simple majority in these matters?
In the House, in the Senate, there's something called a filibuster that makes it very difficult to pass legislation. You basically need 60 senators to overcome a filibuster in the Senate. But in the House, yes, it's a majority. But I do think, so to be clear, in a system of divided government, it's always going to be difficult, at least in this political environment, to see a lot of movement on voting rights in federal legislation. This hasn't always been the case. The Voting Rights Act was bipartisan in 1965, just like it was bipartisan in 2006. So it's not that this is historically true, but it's just that in times of high polarization, that is the reality of the world. And so it really will take sort of one party holding the reins of government in order to see some movement on federal voting rights legislation.
Right. Yes, that's a very grim prospect right now. I mean, I don't mean to be a pessimist, but I want to open, a little bit like the view of all of this, because the fact that you can gerrymander, besides the court having basically approved or given the green light to gerrymandering. I mean, if you would have a different electoral system, namely not a winner take all, but a proportional representation, that would totally change, the effects that these, time, place, and manner of elections would have. What is your opinion on proportional representation as opposed to winner take all in this effect for voting, suppression or enabling?
Yeah, winner take all is a real problem because it results in a system in which you have candidates who win who are not necessarily a preference of the majority of the voters. And proportional representation would address that to some extent, but I do think that we have a I don't even know what to call it, a cultural sort of, just, it's something about proportional representation that the justices on the Supreme Court in particular were very scared of, and also members of Congress. And we saw this in the debates over the reauthorization of the Voting Rights Act in 1982, as well as the changes to Section 2 of the Voting Rights Act. So in 1982, there was a debate over whether or not Section 2 should reach discriminatory effect. Remember, we had that conversation too, because initially the court interpreted it to only reach actions that had a discriminatory intent. So civil rights activists lobbied Congress to change it so that it would reach laws that had a discriminatory impact. During those debates, one of the things that made its way sort of into the legislative history and that the court has hung its hat on is that Section 2 does not require proportional representation, right? This was like a huge thing that was sort of key to Section 2 being reauthorized in 1982. So for some reason, as a society, we just do not love proportional representation, even though I think most people recognize the problem with winner take all and the fact that it does result in election outcomes that are not representative.
Yes, I'm blown away. I mean, I don't want to impose kind of Argentina's electoral system because, of course, it's not ideal. And interestingly enough, the Constitution was modeled, of course, after the U.S. Constitution. And in 1994, in a constitutional amendment, the Electoral College was abolished, something that is strongly tied to curtailing and not curtailing, right? The intention and actually success of curtailing voting rights. But with the language of reasonable burden to give the equal or a fair opportunity at representation, right? I don't know the exact wording. I'm missing the exact wording of the law. It seems that the winner takes all goes completely against, that spirit, unless you prioritize accountability of representatives, which seems to be the argument for having a winner takes all. namely you have one district, you have one representative, you are accountable to your constituents, and that's what is prioritized,
I mean, I
right?
suppose, but it sounds too much like virtual representation to me, right? If you have someone who wins with like 35% of the vote, that means that you assume he's not the preference of 65% of the people in the district. When if you have something like ranked choice voting, that would give you a better sense of whether or not the person enjoys majority support, right? Because if voters can rank their preferences and then candidates fall off, the candidates with the lowest amount of votes, and they fall off, and then the votes are reallocated to the voters' second preferences, those who voted for the losing candidate. Eventually you get to a candidate who is the preference of a majority of the voters in the district, right? So there are ways to do this that we just are not very receptive to, and we don't really have good reasons for why we choose to stick with systems that we really know don't work. Outside of we've always done it like this, and it's amazing how that type of path dependence has dictated much of American politics.
Right, because it's self-reinforcing as well, because the winner takes all just reinforces a bipartisan system, right? And not third parties, and so on and so forth, right? So the parties work on. So I have another question. You have this, book forthcoming, and I would love you to tell us, about what we can find, what we will find when we buy your book next year.
Yeah, so the book project, I'm actually really excited about it because I think it's quite timely. Just in a sense of trying to make a larger point than the article we talked about, the spectrum of congressional authority, but a similar point nonetheless, right? But it just places it in broader historical context. So what I do is I look at the evolution of congressional power over voting, starting at the founding, and going to the Jim Crow era. Jim Crow era being, the period after Reconstruction, where you had white supremacists were able to take back many southern states and disenfranchise African Americans. And so I'm looking at how congressional power evolved over that period, because I think it tells a broader story about congressional power today. Because keep in mind, the court is interpreting the Reconstruction Amendments and talking about congressional power. And so I'm trying to tell this a broader story about the scope of those amendments so that we can understand how they changed our system of federalism, how they enlarged federal power over elections, and therefore a lot of federal legislation, voting rights legislation, and in particular the Voting Rights Act, is constitutional. So part of the reason that Shelby County came out wrong is because that context is missing, right? The Supreme Court doesn't understand or is ignoring the extent to which the Reconstruction Amendments changed our federal system and enlarged federal power over elections. So one of the interesting things about the book is that I'm telling this story through provisions that we don't normally talk about. So yes, we talk about the 14th and 15th Amendments, but we don't talk about Section 2 of the 14th Amendment, which allows Congress to reduce a state's delegation in the House if the state abridges or denies the right to vote. It is the only provision of the 14th Amendment that explicitly mentions voting, but we talk about Section 1 of the 14th Amendment and the Equal Protection Clause all the time, even though it doesn't mention voting at all. I also talk about the Elections Clause. We've talked about how that's under-enforced. I talk about Article 1, Section 5, which gives Congress the power to judge the elections of its members. And so there have been times in history where Congress has refused to seat individuals who won because of discrimination in voting, right? So by disenfranchising Black people. And I also talk about the Guarantee Clause, which is authority that gives Congress the power to guarantee to each state a Republican form of government. And by definition, that gives Congress some say over the political systems in the states, right? And so it really does tie into the argument in the article about looking at congressional power in the aggregate. And so if the reader agrees with me that this is an approach the court should take, well, there are all of these other sources of authority that we can add to the mix, in addition to our traditional reliance on the 14th and 15th Amendments, right? So thinking about congressional power in the aggregate means thinking about congressional power across all of these provisions and not just the 14th and 15th Amendment.
Yeah, that sounds great because that's also provides a source for argumentation, for civil society. If you would, if you mean if that argument gets to the people, and it sounds idealistic in a way, but I think that, when you put ideas out, then you mobilize, along those ideas. So it's very important that these ideas get out and actually kind of people understand that, the states do not have almost ultimate authority over these matters, and Congress, and we could influence, Congress through these matters, um, too. So, I have one question. I mean, I was going to ask, during the, the Q&A later.
Mm-hmm.
What about electoral college?
The electoral college is a struggle. Because I do think most people don't realize that they're not voting for president, right? Because we always we talk about the importance of the right to vote. But the electoral college, you're actually voting for a slate of electors who then meet in their respective states, and they cast their ballot for whoever in most states, whoever has won the popular vote in that state. And so it's entirely possible for a candidate to win the popular vote nationwide, but lose the electoral college because they have not won enough states to get them to 270, which is the magic number. So the 270 number comes from, that's a majority, simple majority. Each state gets a number of electors equal to their congressional delegation. So their number of House members they have plus their Senate delegation. And so people vote, each party offers a slate of electors. People vote for the slate. If you're a Republican, you're voting for the Republican slate. If you're a Democrat, you're voting for the Democratic slate. And that's the electoral college. And it's really interesting how the electoral college developed. The story is that they were really tired, right? That they were at the end of the Constitutional Convention, and they managed to come up with this electoral college. But importantly, part of the reason that they rejected the idea of a national popular vote is because it would have disadvantaged the slave states, who substantial portions of their populations were enslaved. And so the electoral college was a way of essentially protecting a political minority. Or because Virginia was the most populous state at the time, but it was the most populous in part because of its slave population. So it's really interesting how we have sort of this relic of slavery that still dictates our system of presidential elections, and sometimes results in outcomes that are contrary to the preferences of national majority. One other point is, do we still, and maybe this is a question for the audience, do we still need an electoral college, right? And that some people will say that we
don't have it anymore. Yes.
So I've been trying to be open about contrary views, right? So some people would say that maybe it's better that we have a system in which you have 50 different states who are basically running the presidential election in this time of hacking from other countries, right? Because it would be very difficult for a country to hack, every state. But even that argument, if I'm being honest, didn't sway me, because you only got to hack a few, right? You only need to hack Pennsylvania, Wisconsin, maybe Iowa if they end up being a swing state this year. I don't think so though. But North Carolina, Florida, there are only a select few states you have to hack. So even the argument that we need the electoral college because it keeps our system of elections secure doesn't do much for me. So I am definitely anti-electoral college.
Yes, no, I was going to say if you need further arguments, I mean, because this discrepancy between the popular vote and the electoral college in terms of legitimacy, first of all, it's a huge issue. Then there's no equal protection in terms of representation, right?
Yeah.
It's understandable why that came about. And what really kind of puzzles me in all the contradictions that this country has, and one of the arguments the electoral college is so that we don't allow the plebeians right to vote, and we have like illuminated representatives that to elect the president in a very Burkean
yes
understanding, right, of
It's
what,
very, very odd.
of what politics, is. On the other hand, those supporting that are the most anti-intellectual, if I may make this kind of empirical
Hmm.
generalization, right, over
Hmm.
sweeping generalization. They are the ones who support the argument for alleged elitism in the
Hmm.
election of the president.
Yes, yes.
So it's insane.
It's
And there,
very, it's very unusual. I think you're absolutely right that there's essentially, it's based on this idea of the tyranny of the majority, and there has to be some type of filter in the middle between the elective office and the voter, because the voters don't know what's good for them, right? It's a view of voters in which voters as a entity lack independence, and so we need electors.
and we go back to the very beginning of our
Yeah.
conversation, and it's an excellent way to give room to the questions, as it's independence, but in a way it is the patronizing of a certain part of the population saying we know better than you, and you shouldn't do this, we're going to do it for you,
Hmm.
right?
Yeah.
And it goes to who's a member and who's not a full member of the political community. Franita, I would just talk endlessly with you, but we have an audience, so I'm going to stop monopolizing the leverages of the questions, and I'm going to give way uh, to the audience question. Please ask questions through the Q&A feature, so I don't have to look at several panels.
Yeah.
So one question at the very beginning was, what are the northern violations? This is by Larry Schiller.
So if I recall correctly, that's in the context of the Voting Rights Act and who should be covered. And
Yeah.
so there are northern states. So keep in mind, Section 2 of the Voting Rights Act applies nationwide. So there are states in the north that have violated Section 2 and engaged in racial discrimination in voting. And it's also not just states in the north, right? So obvious examples are Ohio and Wisconsin. They've been really bad on voting recently, but
Mhm.
there are also states in the West that are terrible as well. So Arizona, there were parts of Arizona that were covered by Section 5 of the Voting Rights Act, right? So another example that comes to mind is North Dakota. North Dakota passed a voter ID law that required that the ID have the person's residential address, name. The problem is that North Dakota has a huge population of Native Americans who live on reservations with no addresses, right? And so the voter ID law was passed specifically designed to disenfranchise that population, right? So it's not that voter discrimination is limited to the South. It's just that the South had historically been really, really bad. But there are definitely states in the North and states out West, like California disenfranchised Asian Americans for a long time. So
Mhm.
it's not. This is an American problem. This is not just a Southern problem. Yeah.
Mhm. That's actually a great point, because there are all these kind of assumptions and
Hmm.
implicit understandings that actually need to be deconstructed to have like a thorough understanding of everyone involved in this process. So I have Jonathan Marsh asking, each party, when it had a Senate majority, had limited the filibuster for judicial nominations while
Hmm.
returning it otherwise. Why couldn't a similar limit be used for voting rights as well? That's good. That's good.
It could. There's not the Senate. The Senate decides how to use the filibuster. There's nothing constitutional about the filibuster. That is a Senate created mechanism. So it certainly could. Right. This is all a part of their rules. This isn't something that the Constitution requires. So I agree. It could.
Mm-hmm. So a question by Elizabeth Frommer. We've had recent elections where candidates can win about 60% of the popular vote, but still lose the electoral college. Yes, it is time to remove the electoral college, but what are the obstacles? There's a great new book. I forget the author, about ways to, yes, to
I don't know if
it
you guys
can
could
be
see it.
done by state by state. instead of having the 2/3 majority that is required for a constitutional amendment. But I leave it up.
No, I do think that so there are some options, right? Because outside of constitutional amendment, each state decides how to allocate their electors. There's nothing to prevent each state from deciding that it's not winner take all, right? That they want to use some type of system of ranked choice voting, some instant runoff, something other than winner take all. They could do that. Maine and Nebraska, for example, has a different way of allocating their electors. They do it by congressional district. And then they reserve a certain amount to go to the winner of the statewide vote. So there are other ways of doing it. It's just that 48 states tend to do it in this very set way. One proposal on the table right now is the National Popular Vote Compact. So a certain amount of states have signed on to this compact where they pledge to give their electoral college votes to whichever candidate wins the popular vote nationwide. The problem is that I'm not sure if that's constitutional. In part, there's a concern that you are basically altering the constitutional structure through a statute.
You're reversing it.
Right. You're bypassing Article 5. Yeah. And so I don't think the current majority on the court, to the extent that they ever reach enough electoral college votes for it to really have force, I don't think that they would sign off on that. So that's kind of the problem with the National Popular Vote Initiative. And of course, there's constitutional amendment, which probably won't happen.
That's interesting, because when I heard the argument, the author was interviewed by, Chris Hayes. How can I forget his name? Anyways, and I didn't think about that, but it makes total sense because it reverses the order of how, the president should be appointed. So that's a great point. So Karen asks, can you address the recent court decisions regarding the independence or lack of thereof of how elections are required to vote?
Yes. So the faithless elector cases that were decided in June or July, the term went late this year. In those cases, the Supreme Court basically held that states can fine or remove electors who don't vote in accordance with the popular vote as required by state law. Now, every state doesn't have those requirements in place. Like, sometimes they may not have like a law that penalizes an elector for being faithless or that removes an elector. Sometimes it goes to Congress and Congress decides, but that's rare too. So even though 2016 had an unprecedented number of faithless electors, a faithless elector has never determined the outcome of a presidential election. And so I do think, though, even knowing that, the court's opinion, you can tell they were sort of motivated by this concern that if they prevent states from being able to do this, it could lead to chaos, right? Even though it's never happened, there was, you read the opinion and you definitely sense that is a concern that they had, right? They want to avoid the chaos that could come from electors deciding to be faithless in their voting. So states can penalize them if they do so, or remove them from the slate.
Why are they called faithless? Like, why is this thing?
Because when you become an elector, you pledge to support your party's candidate.
So it's by mandate, basically.
They're cheating on their candidate.
Right. It's by mandate. It's not by conscience. It's by mandate. It's not independent elector. In representation, you have by mandate and independent. And so the electoral college is definitely by mandate. Is that written in
by Monday? What do you mean?
Mandate, no, by mandate.
Oh, by mandate.
Accent.
No, I feel you. I have an accent too.
I'm used to
it. So which part is by mandate? I'm sorry.
So if they're called faithless, it means that the electoral college constitutionally is by mandate, right? That if they elect and they pledge to, or they have the independence to write, or this has become a de facto system of allegiance with the party.
Keep in mind that under the Constitution, states retain control over how they delegate their electors, right? So they can decide the state legislature can decide to just say, we're going to give our electors to candidate A instead of candidate B, right? So that's what the Constitution says. So states actually determine how they want to do this. So any state laws on this issue is because the states have decided that they're going to have an election, and that people are going to vote for electors. And then each party will designate a slate of electors, but that's all driven by the state, right? The state can decide to do something different.
Right, right. So basically, yeah, I understand. It's not by mandate because you mentioned
Right.
before. I mean, and actually, I was amazed when I found out that actually electors, they're not bound to do it one way or the other, that they can decide. Um,
Yeah.
they're like ostracized by being called faithless, basically.
Yeah. Because, I mean, part of it too is that electors are partisans, right?
Right.
So political parties are choosing, party adherents to serve in this role.
Mm-hmm.
So,
Mm-hmm.
that also makes it unlikely that you'll have a faithless elector. And it hasn't happened, it's happened definitely, but it hasn't happened like a ton of times throughout our history
Right. That's interesting.
because they're partisans. Yeah.
That would make a great book. I'm just saying. Um, Not that you don't have enough. So I have like a former question. Scott Pinsky asked, what's your take on Justice Roberts? Well, we're diverting here a little bit.
Hmm.
He's right thinking on some days and retrograde on others. I have read that he's concerned about a legacy of respect for the court and so tends to avoid extreme positions, but he seems like he's all over the place. I suppose he's better than a Clarence Thomas or other Scalia proteges, but he seems to have no real principle.
He has principles. He's an institutionalist. And so I do think that his method of judicial interpretation is in service to that principle,
Mm-hmm.
right? So he's trying to protect the legitimacy of the court. He believes that's best done through minimalism. But make no mistake, he's conservative, right? If you look at his opinions in race cases and in voting cases, they embody very conservative positions. The same-sex marriage case, he voted against it. Like he's a conservative, but he's willing to cross over if he feels like a broader decision, even on an issue that he probably cares about, will endanger the legitimacy of the court. I suspect he would probably have a different voting record if he wasn't the chief justice and if it wasn't the Roberts court, right? So a part of this is about the court's legacy, but it's also about his own.
Right, that's interesting. But if I may kind of follow up on that question on your answer, what does it mean, the legitimacy of the Supreme Court? Because again, we
Yeah,
see that for like a vast,
that's all
I
they
don't want to
have,
say
though.
majority of people, but group of people. I mean, what the Supreme Court is saying is definitely not legitimate, according to well, the principles and the piece of legislation of the constitutional, just like you mentioned, but for others, this is the way the country should be. So,
The court polls higher than the other branches of government, right? People clearly like the Supreme Court more than they do the Congress, which routinely polls at like 9%. Right? And it's interesting because their reputation is essentially all that they have. Remember that the Supreme Court doesn't have the power of the purse or the sword, right? This is why the founders thought that they would be the weakest branch of government. But part of the reason they've been able to emerge as one of the more powerful branches of government is because they've been able to keep their decisions within the realm of popular support. And so going too far in either direction could undermine that. And essentially, you can get back to the point where the court is essentially powerless. All they have is their reputation.
what would that scenario be? I mean, if it's not now, I follow what you're saying and I
Mm-hmm.
understand, but I mean, what would that scenario be if it's not this one?
That's Andrew Jackson, 1830, saying, Marshall has his decision. Let me see him enforce it. Right? We still live in a situation where the Supreme Court issues opinions and the other branches follow suit.
Okay, so there could be kind of rebellion, you mean? I didn't know. I mean, I jumped into US history later than 1832. So that's interesting. And since I'm not having new question, I wanted to give you also the chance to just to comment if there's any other issue that you would like to comment on that you haven't touched upon.
So No, I think we did a pretty good job covering a lot of my work and a lot of things going on now. I would encourage people. So I am a voting rights advocate. You know, I'm not a partisan. I don't care who votes as long as people vote. And so I just would encourage people who are voting from home to request their ballots. And if you're voting in person, have a plan. And also poll workers. We will be short of poll workers. So if you are, you know, in a position where you can take steps to protect yourself, serve as a poll worker. So I just wanted to sort of make a pitch for those things, because I do think that we are entering a period where it's unprecedented challenges to voting. You know, most voting will be taking place by mail. We will not know who the winner is on election night. Think about this as election week, possibly. There will be some states that are undecided because under some state laws, people cannot start counting the absentee ballots until election day, right? So we may be in for a bit of a wait, and that is okay. That doesn't mean the system has broken down. It just means that people are counting. So I would encourage people not to think in a horse race mentality where there has to be a winner on election night. Also vote. And yeah, I think that's, and part of the reason why in my talks I've been trying to be more aggressive about encouraging people to make sure they have a plan for voting is because one thing that the Supreme Court has shown us in the last few months is that they will not step in to make sure that people can exercise their right to vote in a global pandemic, right? They did not save the voters of Wisconsin in April. Those people had to go stand in line, you know, without really having a plan because they didn't receive their absentee ballots at the time that they requested them. And that was the state's fault. The voters a lot of them did what they were supposed to and still did not receive their absentee ballots. So if you plan on voting by mail, request it now or as soon as you can so that you don't encounter that type of difficulty.
What I would also, this is great. What I would also encourage people, I mean, not that I'm plugging in, you know, TV shows here, but the daily social distancing show with Trevor Noah has been advocating. No, I found this important because he's actually saying like a lot of people can't volunteer to vote. So please volunteer, like spread the word with youngsters. So grandchildren in the audience or people that you would know that, you know, these positions, even if very little, they get paid, you know, poll stations. So I mean, he says it's a great way to get some money and help grandparents. But I don't know, it's just good, you know, like the people who usually, you know, volunteer at the poll. So people are asking also, Franita, I gave the reference of your article. Is there in the chat? I would ask you to look at it and see whether the citation is correct.
Yes, although I do want to, I'm going to also drop in the chat something else I wrote that's a little bit more accessible than the article. The article is very jargony. And,
it's very jargony.
Yes,
it took me some time. I'm a political theorist and a lawyer. And yeah, so if you can share that with everyone, you know, that would be.
Yeah, I dropped a link to a short piece I wrote about the status of our democracy, particularly in light of the protests that have been going on for some months now. So that I think captures some of where I am in terms of my thoughts on these issues.
So in terms of lower courts, since we have, you know, some minutes left, what would you think? I mean, this is a question of basically who's appointed and who's on the political plaintiff, right, to occupy those places, because the lower courts, once they get on a trend to favor state sovereignty and curtailments of rights, they're going to follow on that path unless there's a substantial political rehaul of judges, right?
Yeah, there has to be some emphasis on the left in particular about the importance of courts. The right has been very vocal for decades at this point about having conservative, not only Supreme Court appointments, but lower court appointments as well. But that has not been a sentiment that has been shared equally. But, you know, when I talk to colleagues of mine who are conservative, they're very excited about the pace of judicial appointments and the types of judges that have been appointed to both the lower court and the Supreme Court. Whereas people who tend to be more liberal, the courts have not really been that huge of a focus, but it's very important. And I hope people understand how important it is going into 2020, the 2020 election,
Mm-hmm.
where not only are you voting for president, you're voting for state representatives, you're voting for local elections, and the Supreme Court is also on the ballot. The next president will have probably 2 or 3 Supreme Court appointments. So it's a very important election.
So it's a very important election, and I know, of course, you work from the legal, institutional, constitutional perspective, but what do you see, or if you see, you know, in terms of how civil society relates to legal institutions, right? What is the role, or how do you see people participating? Because a lot of people in this audience, besides voting, would like to do something else, right? So if you see, you know, in terms of civil society, which organizations or anything that you could share that you know that is happening, that would need more support, participation, if you want to share.
There are a lot of organizations that do work around this. One organization that comes to mind who has been especially active in recent years, I was in Florida for 8 years, and they were incredibly active. The League of Women Voters. They are always in need of people who, because they run voter registration drives, they file lawsuits. They're incredibly active. But there are others. I would just have to sit and think about it, and I can't call it off the top of my head. I'm sorry.
Right. If may I abuse your expert, you know, your knowledge, and if you can send me the list so I can
Yeah,
share,
sure.
because
Of course.
you know I'm getting asked, and I am having like a last question. The makeup of the electoral college, is it slightly not skewed towards the smaller states? I mean, we partly addressed it. Is the college not made up of equal number of electoral votes per state, and then added to that a population count, meaning that the smallest state might already have weighed out with a designated allotment without adding a population count?
I mean, it is skewed towards the smaller states, but in the sense that the Senate is overrepresented by the smaller states, right? Because every state gets 2 senators, whereas the House of Representatives is allocated based on population. But in Wyoming, you get 2 senators and the same amount as California, even though California probably has 100 times the population. So it's skewed in that sense, skewed in the sense that because the Senate is malapportioned, but
Someone has sent a question and then deleted.
oh no, I answered it. She wanted the link to the article, so I gave it to her.
Okay, sorry. I'm trying to be on what you are saying, but you
Yeah.
know, tell me. And so Franita, this is great. If we have like another question, you should send it right this second, not you. I mean, people. Everyone is sending messages that they're very alarmed, and we are too. We're doing the work.
Yes, be alarmed. Absolutely. Like alarm is good, because I think that, we are living, this is a historical moment. This will be a moment that historians teach in their classes in years to come. So we're living in a moment, right? This election will decide who we want to be as a democracy.
Yeah.
And this is why I share my shorter piece, because I wanted to, remind people that if we are claiming to be a democracy, you actually have to do work around that. That it's not just about saying, oh, America's a democracy. No, that means that, it shouldn't be so hard to vote if we are truly a democracy. That our elected officials and their policies should reflect the preferences of the majority if we're truly a democracy. Like, democracy entails certain things that we've fallen short of. And so I do think we're living in a moment where people should be alarmed.
Yes, and if you are also aware, because I am not, but not because I looked for it, like in California, if there are these flagrant violations of voter rights, be in terms of, ID, locations, you name it, if you can share them also with me so I can spread them. There are tons of people who are asking, to have opportunities to participate and make a difference, the damage that is being made to democratic institutions in this country is beyond imagination.
Right.
Particularly a country that has been founded on the imaginary, right, on this founding myth of liberty and equality for all, which is like as far as it could be from the condition of possibility of that founding that was slavery as well. And we see, you know, these forces, you know, fighting right now.
Yeah.
You know.
So one thing I will say, and if it's okay, I probably have to go after this. My computer is about to die, unfortunately. The American Democratic Project is aspirational. It always has been, right? We have over time evolved towards a more perfect union, right? The moment of the 1960s, the fact that we had amendments in case law and federal legislation, all these moves towards broadening the electorate was a step towards making us a more perfect union. So we can come back from this, right? Since 2013, there has been so many restrictions on the right to vote. So many states have taken steps to shrink their electorates. None of that is permanent, right? All that tells us is that the fight continues. And I think that to some extent we got complacent because we had like this high watermark that led to higher turnout rates among groups that were historically disenfranchised. We got comfortable. So if anything, the lesson of this moment is the importance of continuing the fight, even when it seems like everything is okay.
I think that that's an amazing note to end. It's a note of calibered optimism, if I may put it in these terms. You know, it's just we shouldn't get too comfortable with what we have acquired because, you know, history, not only in the US, but everywhere, shows that you have to hold on to what you have and fight for more because no one is going to give you anything extra, right?
Yeah, it's important. We have to understand that America is not inevitable.
I could say a lot of things about that, but you know, the caliber, yes, it's not, yes. So on this caliber optimism, Franita, this has been an amazing conversation. I've had tons and tons of comments. We should spread this out. Is this being recorded? It is. And hopefully we can continue to be, you know, in touch. If you send me more resources, I'll share them with the audience. And for those of you who signed up for the discussion session with me, not with you, you're off the hook right now. Your computer is gonna die.
4%.
So, thank you, Franita, so much.
Thank you. I really enjoyed it.
Thank you, Professor Tolson. We had a great time. I really enjoyed it. And I'm getting a bunch of people asking if you want to work for the Fromm Institute. So we're going to have to talk sometime. And thank you, Mara.
Thank you so much.
Okay, goodbye, everyone. I'll see you later at the discussion session for those of you. Thank you, Franita. It's been a pleasure.